Welcome to the Rucker Report, Criminal Cases Explained.
Everybody watches the verdict. Lawyers watch everything else. Welcome to the Rucker Report, Criminal Cases Explained with board-certified criminal defense attorney and former prosecutor, Wes Rucker. Wes has handled everything from homicide trials to white-collar investigations, and on this show, he breaks down the courtroom strategy, cross-examinations, media narratives, and legal moments most people miss when a case explodes into the headlines. I'm Lisa Mosbey, and today we're talking about how to watch a high-profile criminal case like a lawyer using real cases in the news. Welcome, Wes. Thanks so much for joining me for this conversation today.
Hi, Lisa. Thank you.
Yeah. Wes, what are lawyers watching first in high-profile cases that most viewers never even notice?
So when I watch a case, I like to watch it like I'm watching a football game or a basketball game. I'm familiar with both sports. I'm an avid fan of both sports, and like most people that watch football games that are fans, they're looking to see which side has what type of players. I look at that when I see the lawyers. I'm looking to see what type of lawyers are in this case. What are their strategies? What are their temperaments like? How good are they? And then I also like to look at the judge. And that's kind of like a referee. Baseball is notorious for having umpires that are really bad. Trials are the same. You'll have really bad judges. You'll have really bad lawyers. You'll have fantastic lawyers. And so those are the first things I look at when I start to watch a high-profile court drama.
And then what usually tells you early in the trial whether one side is actually controlling the courtroom strategically?
Personalities are a big indicator. If you find lawyers that are more on the cantankerous side or appear unorganized, that's a signal to the jury and even to the viewer that they may not have control of the situation in the courtroom.
And what separates a cross-examination that genuinely helps a case from one that creates a viral moment online?
So a lot of the high-profile cases, there's one in particular, the Afro Man trial, which I thought was a riot of a trial to watch. That's the case where the defendant took the stand. It was a civil trial, but he took the stand and it actually helped his case. He's a very likable guy. He had great answers. He's a very dynamic person. And so he actually, in my opinion, furthered his case and helped his cause by testifying. The lawyer that was attempting to cross-examine him could not pin him down. And any question he asked, which he thought maybe was an I gotcha, the client was able to turn that into a positive for his side. It was pretty masterful. And you rarely see that. Usually when your client testifies, things can go very wrong.
Yeah, I wondered about that when you said he took the stand, because that's not common, is it?
It's not common in a criminal case. In a civil case, that's different. But the game is the same. You're testifying as the accused or as the plaintiff, and you really have you're walking on thin ice with a lot of your testimony.
And then, Wes, what are the moments during a trial where you can actually feel momentum start shifting from one side to the other?
That's a good question. As an attorney in the trial myself, I can usually tell an opening statement. For instance, if I would, back when I was a prosecutor, if I heard the defense get up and do an opening statement that was not even plausible, that I knew the evidence wouldn't even come close to showing, I already knew I'm a step ahead. And the same is true on the defense side. When a prosecutor gets up and starts to oversell their case, or it becomes obvious they're not really aware of all of the evidence, I can tell at that point. For jurors, I would imagine, they won't see the momentum shifting until the evidence starts to get laid out. And then if the prosecutor has laid out a theme, an opening statement, and then the evidence starts to unfold according to the prosecutor's theme, they're starting to win. And on the defense side, you can start to feel that the jurors are noticing that everything being sold to them so far is happening. That's when I think, a layperson watching a trial would start to see the momentum shifting.
And I'm curious, what kinds of reactions or signals are experienced trial lawyers quietly watching for from jurors throughout the case?
Yeah, I love that question. That's a very difficult endeavor to take on. I've given up trying to guess what a juror's thinking, and that's from watching other trials, and that's from having them myself. There's a legendary story. I actually talked to one of the attorneys that was involved in the case. There was an older defense lawyer. His name was Sid Crowley. He was just a legend down at the courthouse. He was a former prosecutor also. The rumors were he slept at the courthouse. But he, just to kind of set the stage, he looked like Santa Claus. He was kind of disheveled. He was brilliant, but he wasn't the best in front of a jury. But he was an extremely talented lawyer. He knew the law inside and out. He was very good in trial, but just a very large character. So Sid was in trial on a murder case, capital murder case one time, and he was telling me that the jurors were not looking at him except for one, and that juror was making eye contact with him, giving him head nods during his cross-examination. And then when he got to his closing statement, Sid thought he had really done probably one of his best closing statements on this case. It was a very hard case for him. And the juror that he was believing was on his side, gave him a head nod and even gave him a thumbs up. So he was confident that he had at least one juror in his pocket, and maybe more, because more jurors were starting to go with him and take notes as he was talking. So he's done with his argument. The jury goes back, they deliberate. It takes them 5 minutes. They come back out, and it is a guilty verdict. Not only was the juror that he thought was his pal not on his side, but he was the foreman. And they gave a very quick verdict, and then they came back with a death sentence on top of that. So, that is just an example, one anecdote, but it's really hard to read jurors sometimes. Obviously, when they're getting emotional if a victim is testifying and they're getting emotional, if you're on the defense, that's not a good sign for you. If you're a prosecutor, obviously, you know that you're able to reach this juror about the impact of what's happening. That being said, jurors can go through emotional testimony and still put that aside and come back with a verdict that's the antithesis of that. So it's really hard to read. You can tell, though, when a juror is not happy with a cross-examination. They start to roll their head back, or they sigh, or they start they will be audibly upset with some questions that when a lawyer presses too far or is wasting their time. So those are some things you do look for, but it's really a hard business to get into to try to read a juror's mind.
One of the things that pops in my head is television shows. Many of us have watched lawyers on TV and have a preconceived notion of how things are going to go in a courtroom. How does that affect your presentation to jurors or how you watch them?
Yeah, so we actually will talk to jurors in Texas. We call it voir dire. We talk to them about things they would expect to see in trial based on TV shows, and a lot of that is handled in voir dire, jury selection. You try to go over some things like, hey, you may not see this from the defense that you may expect, or you may not see, if you're the prosecution, you may not see that that DNA evidence that you're going to think exists in every case. So jurors do have expectations, especially based on what they'll see on TV shows or what they see on podcasts. That if you don't have it in your case, you need to address it.
Okay. Can you walk us through a real case example where the public or media completely misunderstood what was actually happening strategically during a high-profile trial?
Yeah, there's two that come to mind. One, a case that I tried myself. A few years back, we had a case with an officer-involved shooting. I was representing the police officer that was in an unfortunate situation where he had to use lethal force. The media narrative, I was getting calls from the New York Times, from, different news organizations, not just in the city and the state, but across the country and even internationally. And the media narrative was essentially that the officer in this case shot an unarmed civilian who was having a mental health crisis. And it's, from my perspective, it's one of those, if the facts are what the media is saying, then yeah, my client probably is guilty. But when I know how the facts lay out, that this is not how this trial is going to go. It's going to be a different verdict than what the media is thinking. That's difficult to overcome, And I was talking to another prosecutor who I think is one of the best in the business. His name is John Jordan. He has had some high profile cases himself, where the media attention is very pro defense. In the Armstrong trial, which is another case that had a lot of public media attention, the family was the family of the deceased was actually for the defendant. That was the son was accused of killing his parents, but all the relatives were behind the son. And so the narrative being released by the defense was he didn't do it. And so ironically, the state now had the hurdle of overcoming the media coverage. And in that case, I think once you get past the hype of the media narrative, it was pretty clear what happened. In my case, it was very similar. It was an officer that was put in a terrible situation by someone with a very long criminal history with gang membership, was not in a mental health crisis. And so once you've kind of peeled back those layers and put that evidence forward, you're not really worried that the jury's just going to fall back on what the media is saying.
Wes, what tends to damage a witness's credibility the fastest once a jury starts watching them closely?
Yeah, the obvious, the first thing that will deflate a juror is if they're lying, if they have inconsistent statements, for prior testimony, or they're caught, in a what we call a Matlock moment, where they're caught flat-footed, they're lying. Those are great moments when you're an attorney, when you catch a witness doing those things, but those don't always happen. Witnesses that will not answer a question or they're trying to overhelp, those are some of the most dangerous witnesses when you're putting them on, when you're the proponent of those witnesses. You try to evaluate those witnesses ahead of time. I've had witnesses that were going to testify in one of my cases that they were trying to help, and they weren't there to really tell the truth. They were trying to oversell a narrative, and I wouldn't put them on. Because I knew once they got on, even if they're an insignificant witness, if they took the stand and the jurors thought they were lying, your whole case is in jeopardy. The other type of witness that I was telling you about are, witnesses that just won't answer the question. I remember as a baby prosecutor, 1 or 2 years out of law school, in those days, you're trying DWI cases, for instance, against some of the bigger attorneys in town. So you're outgunned. Technically, you're outdone skillfully. They're just going to be better than you. But you do have the evidence in theory. But one of the things that will drive you crazy as a baby prosecutor when these cops will not answer the question. You kind of want to call a timeout, and stop the proceedings and get a hold of the officer. Those are things you learn over time to, you need to prepare the witness to say, hey, look, you've got to just answer this question and only this question. But it still happens.
Mhm.
And so jurors do not like witnesses that won't follow the rules of the court. If they're asked a yes or no question and they respond with anything other than that, that can be deadly to a witness's testimony. The master of that would be Rusty Hardin. If he has a witness that just won't answer him with a yes or no, when he's asking yes or no, he will disembowel that witness right there in front of everybody to see. And you could have a airtight case, and it's now just been destroyed by a witness that won't answer the question.
Wow, what a challenging place to be in. You're somewhat of a ringmaster managing all the eyes, all the conversations, all the questions, everything that's happening. What changes strategically once a defendant decides to testify in a high profile criminal case?
So anytime your client testifies, you're nervous. The rule of thumb, Law School 101 is you never let your client testify. And that's for many reasons other than they did it. The assumption is, or the presumption is in the public is, well, he's not going to testify. You tell your client not to say anything because they're guilty. And that's not true. There are many reasons why you wouldn't testify. When you're the accused, it is a very difficult position to be in. I had it explained to me when I was a younger lawyer that, when you're a witness and you're an elderly nurse, you're just an elderly nurse and the jury really likes you. If you're the accused and you're an elderly nurse, well, you're a murderer pretending to be an innocent elderly nurse. So that's how the jury starts to view you. So anytime you want to put your client on the stand, it has to be for a very good reason. Because the juries they're very harsh on the accused. You also have prosecutors who are salivating. They're waiting to cross-examine the accused. Usually, even if you don't have much to go on during their testimony alone, the prosecutor will find some things to just rake you over the coals. I've seen cases where, I mentioned the Afro Man trial. That is a very rare exception. That is a case where when someone testified, it looked they really won the case. That usually doesn't happen. A lot of times in self-defense cases, your client has to take the stand. In Texas, especially, in order to get proof of self-defense, there's got to be some evidence of it. And usually that evidence can come from eyewitnesses, but you very rarely have eyewitnesses in a self-defense case for murder. And so you have to put your client on. That opens them up to areas of cross-examination that normally the state wouldn't be able to put into evidence, like their character. Some character traits would come in, prior convictions would come in. So it's a very dangerous game to put a client on or a witness on. If you're the state, you're looking to win the case by your cross-examination. I've seen, there was a very high-profile case, one involving a very talented prosecutor, very talented defense attorney, the David Temple trial. The state was represented by Kelly Siegler, who's one of the best prosecutors, in my opinion, to ever walk the earth. And then, of course, Dick DeGuerin was the defense, and he is, one of the best also. So you had two really good lawyers going at it on both sides. During their first trial, most people on the state believed they were going to lose. After the state rested, in fact, there was another prosecutor on that team who thought this was going to be an acquittal. The defendant insisted on testifying. He did testify, and that case went from potentially a not guilty to a guilty just on his testimony. The jury, as it's kind of the classic pitfalls where the jury just didn't like the guy, and he fell into a lot of traps to a skilled prosecutor, and it went from probably a not guilty to a guilty verdict based on him trying to testify.
Wow, we have to listen to our legal representatives. They know better. They're in those courtrooms all the time. For those folks that are listening, what should people start paying attention to differently the next time that they watch a major criminal trial unfold on the news?
Yeah, if you're a trial nerd and you want to get to some of the more seedy details of a trial, there's not much you can do as far as getting access to police reports or witness statements. Obviously those are going to be confidential or state evidence. However, there are public records such as the filings in a case that will be public. Those can have a lot of salacious details that you may want to pick up on. For instance, a lot of motions to suppress will have a factual statement in there. They may not be true, but you can learn some of the defense strategy based on some motions that are filed. You can learn some of the state strategy by subpoenas that are filed, and those are going to all be public record that a layperson can get access to.
Very interesting. Thank you so much for guiding us through this. It's been insightful.
Absolutely.
That's it for today's episode of The Rucker Report, Criminal Cases Explained with Wes Rucker. If you'd like to learn more about Wes and Rucker Law, visit wesruckerlaw.com. Thank you so much for listening, and be sure to subscribe, leave a review, share this show with someone who might find it interesting, and we'll see you next time.
Thank you, Lisa.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.